Greetings, everyone. Oh, sorry. You go blast. We're going to go ahead and get started. Thank you all so much for coming. I'm excited to see everyone who's here, service providers, landlords, property managers, and others. We're really excited about this event today featuring Judge Catherine Stafford. I'm Mary Morgan. I'm Director of Heading Home of South Central Indiana. We are a relatively new organization that drives long-term systemic change in our system in the 6-county region to really strengthen housing security in this area. And we are all here today because we care about housing security and we're trying to keep our neighbors in housing or finding housing, and evictions are a piece of that puzzle. Judge Stafford was first elected to the bench in 2018. Did I get that right? Awesome. And has been instrumental in leading eviction proceedings in this court. Very knowledgeable and also a great, energetic speaker. So with no further ado, Judge Stafford.
All right, let me take a moment to say hello and thank you to Heading Home and to Mary Morgan for letting me come and join you all today. I want to take a minute and introduce 2 of my 3 children. Tabalsha Stafford and Eleanor Maynard are here because it's fall break for North, and so they got roped into helping Mom. They're going to be passing out candy later for your great responses to Eviction Jeopardy, which is much less exciting than it sounds. But you'll get candy, so it's okay, right? Look at all the candy. All right. It's so good to see everybody here, people I've known for, quite a good portion of my 50 years, including Ms. Zitlow here, people from Katz, Ms. Pfefferman, Ms. Morgan, people from PC Max, people I see in my court on a regular basis, people I see at the bagel store every morning. You're all welcome and glad to be a part of your community, so thanks for having me here. We're going to talk a little bit today about evictions and damages. This is an interruptible presentation. By that I mean, in court, if you interrupt me, I can send you to jail. That is not the case here. Please, you don't even have to raise your hand. Just shout out a question. Say, hey you, what about this? What about that? Sage green, thank you. See how that works? That was unscripted. That's teenagers for you. What I would like to say is, you can ask me any question. If there's a question I cannot answer ethically, I'll tell you that, and it's no big deal. You wouldn't be in trouble, I would be in trouble. So that's up to me to be in charge of, right? So all I ask is you do not ask me about specific cases. Am I doing okay on sound? Is there feedback? I'm good? Okay. In the back row, will you wave if I need to be louder or softer or move? That would be great. Okay. All right, so we're gonna talk about evictions and damages today, because it's a super horrible case type, and I will tell you, when I first became a judge, I did family law for years. I graduated law school in 1997 and did family law, ran a small practice doing family law. And when I became a judge, my docket included family law and evictions. So I had to get up to speed. I'd only ever been to small claims court a few times. I had to learn about it. And quickly I learned that Thursday afternoons is when I would have a sinus headache from crying so much, because evictions are the worst kind of hearing that there is. In a contested custody case, I can come up with at least some kind of a solution to help the child's best interests. In an eviction case, there's no win-win. There's only lose-lose, because it's bad for the landlord because they're losing rent and they're losing the money it takes to turn over a unit. Maybe not cry-worthy, but still bad. And a tenant is losing their home, okay? So not good. We're gonna talk a little bit about it. That's landlord and tenant proceedings. Now you know where we are. Judge Saltzman is my sister judge. We have 9 judges here on the Monroe County Circuit Court and 1 commissioner who hears child support cases. And Judge Saltzman and I share the eviction docket. So if you go to an evictions case, 99 times out of 100, you're gonna get one of us. Sources of law for housing come from all over. We have to look at the fair housing laws that are federal, as well as state and local. We have to look at Indiana statutes, and we have to look at cases, and we have to look at the county and city ordinances. The city has Title 16 that talks a lot about what is required for rental occupancy. The county has an ordinance that says the health department is empowered to make rental regulations. They have not done so. And I've been talking to the health department periodically over the last few years. They were a little busy with COVID, so we're going to give them some time on that, right? It was kind of a big deal. Don't know if you've heard about it. However, they also have a concern about creating ordinances that they don't have a budget to then enforce. So that's a concern that the county has expressed to me, and I've been talking with county council periodically about that. So here is the outline of an eviction process. First, there is some sort of alleged breach of the lease, okay? What's a breach of the lease? Give me one. Non-payment, very, very common. What's another one? Smoking if it's a non-smoking unit. What's another one? What? Bats? Unauthorized pets. Absolutely. Y'all are great. Bats would probably be more of a wildlife nuisance that it'd be on the landlord to get rid of. All right. I'm not going to rent to you. Don't rent to my daughter, Tabalsha. She's going to put up a bat house in the house. Okay. Non-payment, unauthorized occupants, unauthorized pets, threats to other tenants, that comes up unfortunately fairly often, threats to property management, or the big category called waste, which is damage to the physical unit. We have had a scary number of cases in the last few years where somebody is cleaning a firearm and accidentally discharges it and it goes into a neighboring apartment. I've had that now 2 or 3 times a year. Don't love that. And people will come in and say, hey, I want them to move out. I'm like, yeah, I can see that. That's okay. Meth contamination, real big one. I am very familiar, thanks to Ms. Price and her friend Mr. Bolton over at BHA, thanks, on the meth contamination limits and how that works in the Indiana Administrative Code provisions. If there is a significant enough meth contamination in the unit, it has to be stripped down to studs. It cannot have any cabinets left. All their personal property must be thrown away. No drywall, no flooring, gone. That is very difficult. I've had people have to throw away the urn of their father's ashes, all of their children's toys, and all of their photo albums. Horrible stuff. Okay, so first, the lease is breached. Okay, that's step 1. Now we have a notice of small claims. That is, hello, I am suing you. Okay, that's what the notice of small claims is, because an eviction is a lawsuit. Theoretically, in Indiana, we have this thing called a notice to quit. Who here has seen a notice to quit ever on a case? Okay, they're usually not actually required under statute because there are so many exceptions in Indiana. If you are supposed to pay rent by the 1st of the month for that month, it's not required because you have to pay your rent in advance. If the time for the determination of tenancy is specified in the contract, that's a fancy way for saying the end date is in the lease. Like this is a lease from August 1 of 22 to July 31st of 23. You don't have to use a notice to quit. So a notice to quit is a thing in the law, but it's almost never actually required. Like usually a landlord writes their lease in such a way to fit it into this, so they don't have to do it. If you're a landlord and you have not recently checked your lease with a local attorney, please do so. That is one of the best things you can do to make your life smoother and calmer and have more transparency with your tenants. Still hearing me okay? We're doing all right? Okay. So now you're going to sue someone. You're going to fill out the paperwork on your table. Somebody at your table, please have a pen. You can do this as a group. What I want you to do is to find the piece of paper that is called Notice of Claim. I don't have one. It looks like this. Notice of Claim. If a couple of you want to work on one, if you have a lot of people at your table, that's fine. Why don't you walk around? Tabalsha's going to come around and offer pencils. Okay. So I'm going to give you facts for a little bit. Okay, I'm going to divide y'all right down the middle here. Boop. People on this side of the room, you're going to fill it out as if you're the tenant suing the landlord. People on this side of the room, you're going to fill it out as if you're the landlord suing the tenant, just so everybody gets a little practice. Okay? So on this side of the room, you are the... Thank you. And on this side of the room, you are the... Excellent. Well done. Okay, so here are the facts. As a landlord, you are suing your tenant because the tenant is not supposed to have dogs and the dog bit a neighbor. Okay? So you all fill that out. Okay? As a tenant, it's November, but the heat is not working. Okay? It's cold. It's 20 degrees outside. The heat is not working. So, fill it out. I'll come around and answer questions. How's it going? All right, are you finding it okay? Any questions? Exactly. If you are the one doing the suing, you are the plaintiff. Excellent, thank you. Any questions so far? Any questions so far? Okay. Any questions so far? Okay. Any questions so far? I would think so. Ooh, I would probably go with habitable and utilities. Always check as many as seem to apply, because if I find one that doesn't fit, maybe there's another one I could use. Yeah. There was a question about which box to pick for the reason. Pro tip, pick as many as seem to apply. Pick as many as seem to apply. It's not one and done. Multiple things can be true. Any other questions? Okay, you've seen these. Many times. Doing okay? Doing okay? All right. I love it. Any questions? Love your top. Yeah. There was a great question about what if a notice to quit is not required in this circumstance because one of the statutory exceptions applies. You could scoot right to suing the tenant for eviction, but isn't it a better idea to reach out to them informally and say, hey, here's my concern, what can we do to fix it? Yep. Negotiation, always good. Y'all have any questions? Doing okay? Okay. Any questions? You know me, I just can't leave you alone. I just have to keep coming back. Okay. Doing all right? Okay. Raise your hand if you have other questions if I haven't been to you. Okay, but that's talking about exhibits. We're not to exhibits yet. You're just filing the lawsuit. Okay, so if you're going through your form, how many people are done with the statement of claim portion, just on the very top of the front page? People generally good there? Okay. What about the plaintiff's notice of representation on the bottom of the first page? Are you seeing that? If you are a single person, like you're an actual human, and you are filing, you're a natural person, right? Do you see that on there? Okay. If you are a business, you have to consider how you're appearing in court, because you cannot just appear in court by an employee unless you have permission. Otherwise, that's unauthorized practice of law, and it's actually a crime, which, you know, we don't want to get you in the position of doing. And of course, when they updated this rule, they didn't make it easy to understand, because that would be not in line with how we like to do things. And so there are a lot of exceptions and things about how it goes. So I tried my very best on this notice of representation, which is a form really only in our county. So if you go to other counties, they don't use the same form. They may have their own form. We all operate under the same Indiana state rules and statutes and small claims rules, but our local practices are very different county to county. So don't try using my form over in Greene County or Orange County. It's not a thing. Questions on the instructions to plaintiff on the back. Small claims court has a jurisdictional limit of $10,000, and if it's an eviction case, small claims court has jurisdiction if the amount of rent due at the time of filing the case is $10,000 or less. Well, that's a fascinating question on which there are multiple appellate cases, all of which disagree with each other. So sometimes I've granted more than $10,000 in damages, but usually what they'll do at that point is request a transfer to plenary where they can ask for anything they want to. They're not going to get it because the tenant is probably judgment proof, but okay. Any questions on instructions to plaintiff? Yeah. We don't know. What are they wanting? Right. So if they haven't turned on their heat, maybe you had to buy a space heater. Maybe you want the cost of that back. Maybe you had to go stay in a hotel for a few days. Maybe you want the cost of that back. It depends on the facts of the case, right? And there's no cost. Maybe you want to prorate your rent. Yeah, that's something that you can ask for. Nice, nice. It's hard to figure these out, right? A lot of times I get these and there's no amount in there. But in small claims court, I can't order people necessarily to do things. That's called an injunction or a specific performance. I can only order the payment of money. So somehow you have to reduce what you want to an amount.
What about the physical and psychological damages of living in very cold weather? How does that impact it?
Okay. So you really usually cannot get emotional distress damages in small claims court, but there are a few exceptions. All right. Everybody filled it out? Okay, that was your exercise. The first of a few. You may notice other handouts on your table. There will be more coming. I wanted you to get a feel for what people go through when they come to court and say, I want to file for an eviction, or something's wrong, I need to sue my landlord, right? Now, there are 3 ways to resolve any civil case, whether that be an eviction, or a divorce, or a CHINS case, which is a child in need of services, or a multi-million-dollar lawsuit. All of them have the same 3 ways: negotiate, mediate, or litigate, okay? Litigate is the third for a reason. Don't start suing people first, right? If you are the tenant and your landlord has not turned on the heat, don't come into my court unless you can show me a series of text messages or rental portal messages or emails where you have said, hey, my heat's not on. If you are the landlord and you are coming to me and the tenant has a dog and you've known about the dog for 6 months and you did nothing, and now the dog has bitten a neighbor, that's not as good for you as if you can come in and show me 3 different letters or emails or text messages or something that you've sent to the tenant saying, hey, we have reports of a dog in your unit, your neighborhood barking. I want to make sure you understand dogs are not permitted per the lease. Here's a photograph we captured from the parking lot of you walking the dog into your house. Evidence and attempts to settle the case before you sue people are good. I'm a lawyer, I love suing people. I'm a judge, I love hearing lawsuits. Never the first choice, right? Negotiate first. Second, there's mediation. In most counties, they do not have a great way to mediate small claims cases. Mediation is where there's a neutral third person who sits down with both adversarial parties, either in the same room or different rooms, either in person or on Zoom, and tries to come up with a compromise they can both live with. Are they both going to leave throwing their hats in the air because they're so excited? No, of course not. When I used to mediate divorce cases, I would say my goal is that you're both equally pissed at me by the end of the day, okay? Because that means I've been neutral. So mediation is available in Monroe County through the Community Justice and Mediation Center, and they will mediate for free. So if you are the landlord and you have a tenant who is usually good and pays their rent on time, then you don't want to have to pay $2,000 to turn over the unit, update the carpet, paint the walls, all the stuff, but you're worried about them because they are going through a mental health thing that you're not sure what's going on, and they've started to kind of yell weird things at neighbors. Maybe try mediation and talk to them. Maybe see if there's a case manager. Yeah.
Where was that located?
The Community Justice and Mediation Center, and I will have a phone number and email up here for you in a moment. They have to agree to mediate. The other side does. They don't have to mediate. Like, they don't have to negotiate with you, but you can try. Right? Ask. Say, hey, I'd love to get together and settle this case. What could we do? Right? The mediation service is free because the Community Justice and Mediation Center, CJAM, is awesome. It is free. Okay? Thank you. Hi, Gabby. She is a frequent helper in my court on mediation days. Thank you. All right. Landlord files the notice of small claims with a brief statement of the nature and amount of the claim. So if the landlord just turns in this notice of claim and doesn't put an amount in and doesn't check any of the boxes, when you get that as a tenant, how are you going to prepare for court? How are you going to prepare your defense? Are you going to know why they're trying to evict you? Do you have ESP? Because I don't. I don't have ESP. Do you, anybody? Anybody? ESP? ESP? Ella does. I love my daughters. All right, extrasensory perception? Psychic? Are you psychic? I have a cousin who's a psychic in Nashville. That's a long story. Okay. You have to explain why you are suing them, or they don't have an ability to prepare, right? Do you want to be sued for a reason you don't understand and then show up in court and you don't know what's happening and you don't have a chance to prepare? That sounds like hell, right? Probably once every month or two, I dismiss an eviction case because the landlord did not explain why they want to evict the person. You gotta put a reason. No reason, no eviction. It's that easy, okay? And then there has to be service of process. What's service of process? You've been served, right? Larry, John, I'm mad at you. I'm suing you. There's a copy of my lawsuit. He's been served, okay? It's giving them a copy of the papers so they know about the case, because due process is a thing in our country, right? You've heard of due process. Anybody want to try to explain due process to me? Because it's kind of a weird, nebulous, amorphous, ambiguous concept. Any takers? You playing pool while your mother's presenting? Thank you.
If I were to stab at it, it would be, you need to have all of the things done in the proper order, and everyone needs to know about it all of the time, maybe?
That's a pretty good description of due process. Due process, I like to boil it down to 2 words. No surprises, okay? So if you think about a lawsuit and you think, well, that would be a surprise to the other side, it probably means you shouldn't do it, okay? It's not a thing. The return of service is important. We're going to come to that in a moment. So if you finish the notice of claim handout, now I want you to look at the thing that says initial service handout. On the other side, it says return of service. It's one of the handouts. And it looks like this. Service of process for civil cases. And on the back, it says, it's a form you can use to turn in to show me that you did the service. Okay? Everybody got it? According to Small Claims Rule 3D, you have to turn that in every time you sue somebody in small claims court. Whether you're the tenant, the landlord, the neighbor, whatever it is, if it's small claims court, you got to turn in a return of service. It doesn't have to be on my form, but it should be something that says, yes, judge, we gave a copy to the other side, and here's how. Okay, I've talked about negotiate, mediate, or litigate. Everybody understand the difference? Negotiate is you two on your own trying to solve it. Mediate, you get a neutral third person. Litigate, you bring your case in front of me, you have to follow the court rules, and I get to make a decision. Can I be as creative as you can be in a mediation or a negotiation? No. I'm stuck with just what the law allows me to do, okay? In a mediation or a negotiation, you can say, okay, I get that you're mad about my dog. I don't think it was my dog that bit the neighbor, but I will agree to move out in a month if you let me keep my dog until then, and I will pay you an extra month's rent. Okay? That's not a bad deal for the landlord. It's a good deal for the tenant. Could I make them do that? I cannot. Okay? So that is a great reason why negotiation and mediation are super useful, and please don't forget about them, because you have the whole world. You can agree to anything that's legal. You cannot negotiate to let someone stay there as long as they have sex with you. That would be prostitution, and that's illegal. Right? That's not a thing. You can't agree to let them stay there if they give you all of their cocaine. Again, illegal. You cannot make a contract for that. A legal contract. I cannot enforce a contract for the giving of cocaine. That's a hell no, right? However, in negotiation and mediation, you can agree to anything that's legal. Okay? The world is your oyster. Okay? While you are considering filing a lawsuit, or after you have filed the lawsuit, but before you get to court, that's where you can negotiate, that's where you can mediate, and that's where you can facilitate, which is another thing that I'll tell you about here in a minute. So CJAM, if you want me to tell you the phone number, if it's too small, I will read it out loud. Gabby, tell me if I get this right. 812-336-8677. 812-336-8677, or admin@cjamcenter.org. Okay, admin@cjamcenter.org. Did I get that? We're good? Excellent. There's also a program that the state courts created at the beginning of the pandemic called Landlord-Tenant Facilitation. It has 0 advantages for the landlords, and I've had maybe 2 of them agree to it over the last 3 years of using it, so I'm not going to spend a lot of time on it. I will just say that there is a program for that, and you can do it if you want to. But I don't know why anybody would. It doesn't actually help anything. I love the theory, but it doesn't actually work. Okay, service of process, initial service. So how many sets of rules are there for lawyers or for anyone going through a case? Anybody know? More.
43.28.
Somebody else. I would say there are 20 to 30 for state court cases in Indiana. Sometimes I have to resort to sticking my tongue out because that's all I got. When your kids are smarter than you are, you're really just stuck, right? So trial rules govern regular lawsuits. Small claims rules govern small claims lawsuits. Do you need it? You got it? All right. Except sometimes the trial rules still apply, so it gets confusing. This is too small to read, so I'm going to give you the highlights here on the next page. This is how you serve a case, how you give the official notice of documentation. Here are the big methods, and if you look at the return of service or you look at that handout, you're going to see these methods described right in front of you. Personal service is when I handed the document to John, right? Left copy, mailed copy has to be leaving it at their home and sending a copy by first-class mail. Can I do left copy, mailed copy service where you work? No, I cannot. Can I do left copy, mailed copy service when you moved out 6 months ago? No, I cannot, because it's not your home, right? That is a huge deal. Certified mail with return receipt requested. This has been very difficult during COVID when the mail services people were, of course, rightly scared of getting COVID from taking the mail to you at the door and getting you to sign it, and they would just write C-19 on every return of service form. And so we couldn't prove that anybody had any notice. That was fun. We have to get their signature back, right? We have to be able to track it to know that they got it. Publication is where you see it in the classified ads in the local paper. Who still gets the local paper? All of you, right? All of you get it every morning, right? Right? Everybody reads the classifieds naturally to find out if you're being sued, right? Everybody, every morning? Every morning. Nobody has checked this in like 15 years, but it is still an official method of letting people know that they are being sued. Most judges don't like to accept publication for service unless there is a showing that other methods have not worked. Okay? Waiver. I used to do this all the time in divorce cases. Nobody wants to have the sheriff show up at their work and deliver them a set of papers for personal service, right? So I would just say, hey, have your ex stop by my office and pick up the papers and sign that they received them, and then they don't have to worry about where they're going to get served. That's a kinder, gentler way of serving the case, right? They just sign, yes, I got it. Okay? Special order. I'm doing this more and more and more. This is where the small claims rules relate to the trial rules, and the trial rules permit you to be creative. If you cannot get your ex to respond to you for an order of protection case and you need to serve them, I might let you serve it by Facebook Messenger. I might let you serve it via Snapchat. I might let you serve it via email. I might let you serve it in all sorts of different ways. Eviction cases, I will let them be served through an eviction portal if you can show me that that's where the landlord and the tenant typically get messages and you can get the whole document through it. I need to know, is it effective? Can you get the actual documents to the actual person? And is this their actual email, or is this a fake email you set up with your friend to fake me out on service? Okay? So those are the things I'm looking to prove. You can't just do that without permission of the court. So if you want permission of the court to serve someone in one of those more unusual ways, you have to ask us. And can you just come by our office and ask us? No, you cannot. You cannot talk to us about a case unless the other side is there and we're on the record. Because do you want the judge talking to the other side of your case without you there? Of course not. That sounds scary as hell, right? Judges can only talk to people about a specific case when they're on the record and all the parties are there or have gotten notice of the case and have had the opportunity to get there because, again, no surprises. Due process, right? Questions so far? You're all going to be experts on service of process by the end of this. Okay. Any of those methods can be done by the plaintiff themselves or by the sheriff or by somebody else. But whoever does it has to fill out a return of service. Okay? So I will often say, how are you going to serve that? And somebody will say sheriff service. I'm like, well, is the sheriff going to just put it on their desk and not give it to people? Because that is not sheriff service. Are they going to do left copy, mailed copy? Are they going to do personal? In other words, it's not the who is doing the service that I care as much about. It's the how is service getting done. I'm a townie. I grew up here in Bloomington, but I went to Minnesota for law school. And one of my jobs in law school was doing service of process for clients of the firm where I worked, and it was real fun to be the first person to let people know they were getting divorced. That was a great job. You could not serve your own case in Minnesota, and in many states you cannot serve your own case because you're considered biased as to whether you actually serve them. But in Indiana, oh yeah, you can serve your own case, no problem. Questions so far about service? Yes, please.
Now, if you're suing someone, do you have to pay for the sheriff's service? Do they charge for that?
Yes,
I just wondered.
they sure do. It's about $28.
So I just wondered.
Yeah, no. Yeah, the sheriff charges. Yeah, absolutely. Even if you have a fee waiver for filing the case because you're low income, you still got to pay the service fee for the sheriff if you want the sheriff to serve it. Yeah.
I wondered on the home address for the service. So for example, I think in my lease, there's a line about like what methods or addresses are considered. Does that override that at all?
No.
And then, so some people are pretty slippery with addresses.
Yep,
Okay, yep.
sure are. That's where you might want to look at special service.
So, so say you go ahead and have sheriff service and say, because it's happened personally, of course, say they weren't able to serve the person. Is it a bad idea to go ahead and serve them in one of these forms on our end as well, and then we have that we were able to serve them?
There's no problem with serving somebody twice,
Okay.
or thrice, or force, fourthus. Okay, you know what I'm saying. I'd rather see somebody overserved than underserved unless it's being done to harass or annoy them, which is a thing that comes up in intimate partner violence situations, right? It's the opposite of bartending. Thank you, I love that. Okay, so we're gonna go to the initial service handout. Now, this side, you were tenants before? You were landlords? You were landlords before. This time, you all are tenants, and this time, you all are landlords. I want you to fill out the return of service form on the back of that service of process handout with these facts. So as the landlords, you left a copy on the tenant's door, period. Is that good service? So fill it out and then be ready to tell me if you think it's good service. As a tenant, you sued the landlord and sent a picture of the notice of claim in the rental company's portal. Everybody has a portal these days, right? Right? Y'all know what I'm talking about when I say portal? There's an app for every management company. Okay. So, take a stab. I'll wander around and answer questions and drink my Diet Dr. Pepper. You got it? You're doing great. Love it. Any questions? No? No? You're like, get away from me. Any questions? You didn't know there would be homework, right? Welcome to my world. Y'all doing okay? All right. Any questions? When am I stopping again? 1:30? Thank God, okay. That's a handout that is usually attached to the notice of claim that my staff did not copy with it this morning. Doing okay? Any questions, thoughts, concerns? That is a great question. So tell me what else you would do. Like once you realize you messed up, what do you do to fix it? There you go. Oh my God, every day in my court. Every day I have to reschedule. Thank you. I love them too. They make me so happy. I have them in green, so when I wear a green dress, I wear the green version. Yeah, I don't know why I needed Mike that. That's the most common. And as, all the time. If they bring it it up, but they do it by appearing in court. They've already appeared in court, so clearly they knew about it, so they waived that argument. How it's going to come up is 2 months later they realized they were evicted, but they were. Then they can file a motion to overturn a default judgment. All the time. We have a huge international student population. I legit, absolutely. I have been doing high conflict family law and such since 1997, and I still get surprised every day. Every day. Every day. Y'all doing okay? All right. Any questions? All right. Any questions back here? All right. Doing okay? Any questions? All right. All right. Okay. So landlords, did you do it right? Who's a landlord? Landlords are over there? Table. Okay. So, did you do it right? Did the landlord perfect service?
I don't think so.
What was wrong with the landlord service?
Well, it was not mailed, so the "and" portion is not satisfied in that statement. And
That's it.
I guess that's it.
Right. They left a copy, but they did not mail a copy. So that's half service, and half service is no service. So my job when I hear the case, we are hearing 3 eviction cases every 15 minutes. And so I'm looking at the file real fast, which is, by the way, all electronic, and sometimes that works, and sometimes the systems are down, and sometimes it's super exciting. And I'm looking to try to see a return of service form or anything that the plaintiff filed to show me how they did service. And I'm trying to make sure that all of that is done correctly as we go. But sometimes I miss it. Okay? Anything else the landlord could do once they realize that they didn't fill this out right? Table over here where we discussed this. Any thoughts?
Mail it.
Mail it. Mail it. Am I going to be super impressed if you mail it the day before a court? I'm really not, because how long does the mail take in the city of Bloomington to get to another place in the city of Bloomington? I would say 2 weeks. I mean, I don't want to count on it any faster than 2 weeks. Also, do you all open your mail every day exactly when you get it? I don't. All of my bills and important things are via email or portal or et cetera. I don't open mail but maybe once a month. I just leave it on the corner of the kitchen counter. Currently, there's a plastic Target bag with my mail in it that I had been taking back and forth to the office and home for about 3 weeks, and now it's under a pillow on the other side of my bed because my cat was trying to chew on it. Okay? I'm a judge, right? You've seen the plastic bag?
No.
Okay.
Yeah.
Ella saw it. It's embarrassing, but there it is. There's a plastic bag full of my mail I need to look at. So if you sue me, I'm screwed, right? Screwed. Okay. As a tenant, did you do it? Did you do it right?
No. Only if we ask you permission to use.
Exactly. This is not normal service, therefore you have to have my permission before you do it or it doesn't count. Right? That's service under special order of the court. Is this making more sense? I like to make people do things because then I feel like you understand it more and it makes more sense. But okay. All right. We're going to see if I can juggle the clicker and the microphone and the Diet Dr. Pepper. Yes. I was a waitress for a long time. Yes, questions?
In the scenario of the landlord in this case where they only left a copy at the door, you had said if the tenant shows up to court, they're acknowledging receipt of that. If they do not show up at court, are they able to open their own case against the landlord? Can they ignore the notice?
I would never advise someone to skip court if they actually know about court. However, what I would say is, if you have an attorney, the attorney can file something called a limited scope appearance and fight that service, but you don't have an attorney if you're getting evicted for non-payment, let's be clear. If you get evicted in a default hearing, which means you didn't show up, and I just heard the landlord's side, and I evicted you, which does happen every week, then what you're going to do when you find out about that is file a motion to overturn a default judgment. And I will likely stay my order of eviction until I can hear that argument. And a stay means just, I'm putting it on hold. I press pause. Does that help? Motion to overturn default judgment. It has to be filed within 1 year of the judgment, and it has to show a good faith reason you weren't there. You oversleeping is not a good faith reason. You thinking it was more important to go to your job than court, unfortunately not a good reason, even if you were going to get fired. You being in a car wreck and being able to show me the paperwork and the police report, good reason. Okay? You not getting service, good reason. Does that make sense? Any?
You didn't get service because you didn't open your mail?
Even if you didn't get service because your mail's in a plastic bag under the other pillow in your bed, yeah, that's not a good reason. Yeah. As much as I would like to say it's a good reason, it's not a good reason. Okay. Now, who here, did I skip how many of these? I know I skipped. Okay. Emergency evictions. Who here has dealt with a landlord or tenant situation with an emergency eviction? Okay, about a third of you. You have not. Yeah, I do. I really do. Sasquatch over here. Okay, so when can you file an emergency eviction? Someone's doing damage to the property, Ms. Price? Damage to the property? Yeah?
Threat to person.
What?
Threat to a person.
Threat? Safety issue? A gun discharges?
What about, the police say it's a drug house and they ran in there and got found drugs? Is it?
It depends. I mean, it depends because sometimes people say that and they don't have the paperwork to back it up. And I mean, sometimes people say that and it didn't really happen. Sometimes people say that and it's God's own truth. So when I say it depends, that's not just because it's the lawyer's favorite answer to everything, because we're wishy-washy wusses, but because I want to see the facts, because the facts matter, right? That's why. So sometimes, not a great answer, but it's the answer, yeah, because it depends on the facts of the case. So if an immediate and serious loss, injury, or damage is about to happen, either the landlord or the tenant can file an emergency action, okay? Did you know a tenant can file for an emergency proceeding? Because they can, yeah.
Does that loss include financial loss and injury?
No, never, ever.
So for example, if the tenant is breaking a local ordinance and risking getting a large fine that's attached to the property tax.
Sorry about you. I once had a client who clipped his front lawn with nail clippers. Yeah, I've done every case. I've done every case, right? That would not be an emergency, right? I cannot answer that question as it might reveal too much about my client. Yes.
What if you don't know about the emergency eviction process and you're just a 24-year-old in your house?
Yeah, because did you all know this? And you're adults, right?
Yep, well, I was curious because, well, say a tenant comes to you, goes to the landlord and says, hey, I'm not paying my rent because there's water damage, there's no flushing toilet. How are they supposed to know all this information?
Nobody does. They're supposed to please.
The landlord.
Well, the landlords even mostly don't know about this, okay? So in Indiana, is there a right to withhold rent? There is not. There is not, there's not, don't withhold rent ever, don't do it. Indiana does not have that at all. Almost every other state in the civilized world has that. We don't have that. Don't withhold rent. Now, if you had to spend money to fix it, you might get that money back, but you cannot not pay rent. What you can do is file for an emergency case, and if I find it's an emergency, I have to hear it within 3 business days. Is the mail going to get to you within 3 business days? It is not, right? Nor will people open it.
What happens if I pissed off the landlord and they are stripping out my insulation and then there is a massive cold weather front coming down in like a week?
I would probably call that an emergency. Okay. My whole family, we're real shy. I don't know if you've noticed that. You just can't get us to talk out in public. Yeah. My oldest child is even less shy than all the rest of us put together. Yeah, okay. So there's a special rule locally, which you can tell because the local rule is titled LR for local rule 53 for Monroe County. and it's a trial rule, and it applies in any kind of case in Monroe County, but it is especially relevant to emergency evictions. What it says is, if you file a request with the court, which is really what a motion is, or a pleading, or a petition, and you say, I would like judicial action in 3 days or less, then you have to serve it on opposing parties by fax, email, or personal service, which is again handing to the person him or herself, not leaving it at their house, not giving it to a friend or a relative. And you also have to call them at the time you file your emergency request. I once had not once, it was 2 weeks ago, I had a very highfalutin divorce case with people living all around the world and very high-paid attorneys, and they filed an emergency request, and they forgot to call the other side when they filed it, so I'm not hearing it. That's how that goes, yeah. Then it would be really hard to do this. Yeah. Was this rule written for low-income people? It was not. No. Are any rules written for low-income people? Usually not. Should they be? Yes. It means you better be able to show me personal service, and you better be able to show me you tried to call them. Right? Right, here's the last phone number we had on file, and here's the phone record showing I tried to call it. Yeah.
Say, for instance, someone, it's escalating like a tenant and a landlord, and it's getting aggressive.
Sure.
Does that qualify under an emergency eviction?
Sometimes, yes. I have done emergency evictions on the basis of threats to property management and staff, and sometimes I find that there's a serious enough risk or threat that I evict people on that basis. But again, it depends on the facts, right? Document it, show me your evidence. If you sue somebody, who has the burden of proving their case to me? The person who's doing the suing. If both cases are pretty equal, who do I go with? The person being sued, because the other guy has the burden of proof, right? That's automatically how any case goes. Yeah, I love these questions. Thank you all.
Say the 24-year-old who was, the 24-year-old that was evicted, she did have her rent, she just didn't pay her rent. So she showed the judge, she's like, look, here's my account, I put the rent in it for the last 2 months. They had to buy heaters, and they had to buy new clothes because the water leaked from the upstairs apartment. And do they have the right to sue the landlord now that they've already been evicted and they had to pay back $6,000 in damages that
Yes.
they never did?
Yes. So I'm going to repeat the question. If the tenant got evicted because they failed to pay rent, but meanwhile they had spent a lot of money to try to fix things that were wrong with the unit, that were legit wrong and were reasonable expenses, like space heaters when the heat was out is a great example. And we come then to the damages hearing. Am I going to give them a set-off or a counterclaim for what they had to spend? Absolutely. Yeah. Okay, but you can't tell me about a specific case. If it's not hypothetical, we can't talk about it. Okay, okay. I was like, don't get me in trouble. Okay. All right. Is this making sense? Yes, please.
So there are low-income housing tax credit projects or housing in town that has choice vouchers like that.
Yes.
So they usually have to ask permission from whoever gives them the vouchers, BHA or IHCDA. So what happens with emergency evictions? Can they bypass that?
No, they still have to go through the legal process. Now, there are...
Do they have to get permission from IHCDA or BHA?
It depends on the individual rules of that case. It depends on the rules that voucher or program is subject to. Often there are rules in the Code of Federal Regulations that require good cause or a good faith reason. That's what I usually see. And so they will have to do that. Often it requires the notice that they have an opportunity to have a hearing with BHA or whoever the program is, or that they have an opportunity to be represented if they feel they have a disability. They got to check all those boxes. But if nobody tells me it's a protected property, I don't know, right? I don't magically have an inventory in my head of every housing program that every apartment in Bloomington is subject to. So if I don't know it's subject to those laws, I can't enforce them, right? Question over here.
So I'm just a little confused on why a tenant would file an emergency eviction on themselves, and if they did, would that show on their record?
That is a great question, because what the tenant would file is an emergency request for help. Okay, it's still called a notice of claim. It can be done on this form, and it's still heard as an emergency eviction, but it's not really an eviction. So it's going to show up as an EV case where the tenant is the plaintiff. Does that make sense? Because they're rare. I get, out of every 100 eviction cases, 99 are filed by the landlord, 1 is filed by a tenant, and it's just a case type. It's not meaning they are wanting to kick themselves out. It may mean they want to kick the landlord out, but of course I can't do that. But what it is they think the landlord is violating housing laws and they want relief. They want me to do something about it. So a tenant can sue their landlord and should probably more often do so. Yeah, you can sue. Now, you should try to negotiate and mediate first. Keep trying. I know. Okay. So, we filed our notice of claim and we've served it, right? That's where we are in this timeline. Now, we're to the eviction hearing. I want you to take a notice here that there are 2 hearings as part of almost any eviction, right? The eviction hearing and then the damages hearing. Is there a little pointer guy? Yes, there is. Look, damages hearing, eviction hearing. I don't have to be Vanna White up close. I can be Vanna White with a green dot from back here. Okay. So for the eviction hearing, under the small claims rules, it should be held no earlier than 10 days from the filing of the notice of claim. No earlier than. So you shouldn't be able to file on a Monday and have your case heard on a Thursday. The Landlord-Tenant Task Force during COVID recommended no earlier than 30 days. I will tell you right now, I'm running at about 6 weeks. I'm booked. People say, well, get more time on your calendar for it. I'm like, well, I only have so many hours in the day, and by statute, my order of protection cases and my family law cases with children are a higher priority, and they're going to take precedence over any eviction case, except an emergency case. So the evictions are getting pushed out. If you want a contested divorce in my court right now, it's going to be in February. That's just how it goes right now. Right? Okay, so there are 2 kinds of hearings that you can have for an eviction hearing. The first kind is this initial hearing. If the landlord has filed to evict and does not show up, that's a dismissal, right? You don't show up to plead your case is gone. I dismiss it. Check, gone. If there's the failure of the defendant, who is normally the tenant, but again, not always, in that 1 out of 100 cases. Sorry, I have to have better aim when I'm not looking at it. That's a default. And what happens then is the landlord will swear in I will swear in either the landlord or the attorney will have me swear in their client, and the landlord will have to make what's called a prima facie case. My Latin teenager, what does prima facie mean?
Never heard of facie before, but first.
Yeah, first look, on first glance. Is on its face, is there a case? Prima facie. If I love you so much. Okay. So default is when the defendant doesn't show up. Dismissal is when the plaintiff doesn't show up. If they both show up, the next stage is to try to get an agreement. And so how do we do that? That is where we start using the excellent services of the Eviction Prevention Project. Gabby and Tonda, see if I get this right. This is the announcement I give in court once a week, like 5 times a week. We are fortunate to have the services here today at this initial eviction hearing of the Eviction Prevention Project, which is a collaborative group of local nonprofits who are able to provide some limited free legal services and mediations to people going through a housing case. Would you like to talk to one of those attorneys for free? And usually people say yes. Not always, but usually. And then once they've had a chance to talk to an attorney for 10 or 15 minutes, they come back into the main courtroom, and that can be done by either landlords or tenants, depending on what services we have there that day. Then I say, and now I'm going to ask you to try to come to an agreement. If you come to an agreement, I'll probably approve it, and if you don't, then we'll set you for a contested bench trial in person, where you'll bring your exhibits and your witnesses in and litigate in front of me. And do I try to make that sound icky? Yes. Okay? So then I send them to a different Zoom room, because all of this part is done on Zoom, and they meet with 2 mediators, a team of mediators from the Community Justice and Mediation Center, and the landlord and the tenant try to work out a compromise. Then it's on Zoom.
That's an important point, I think.
Right. The reason that we do them on Zoom started because of COVID. And the reason we kept them on Zoom is because 100% of the participants preferred it. The tenants did not have to miss a half day or a full day of work and risk getting fired. They didn't have to find childcare to come into court. They didn't have to pay gas to come into court. They didn't have to pay to park near the Justice Building downtown. And the landlords loved it because they didn't have to leave their busy offices in the middle of move-in season to come and wait around in court for 3 hours. They could do it on Zoom. They might be on the Zoom for an hour, but only 15 minutes of the time were they interacting, and the rest of the time they could work on their computer or do phone calls or do anything else. Same way if they walk into my courtroom is how I know they're real. You walk into my courtroom, do I check your ID? No, if you tell me you're Charlotte Zitlow, I'm probably going to believe you. Yeah. Same way. I don't believe you. You lack verisimilitude. All right. So I was surprised. I thought there would be a bigger digital divide. I thought it would be harder for low-income people to get access to Zoom. Almost everybody has a smartphone. Not everybody, but most people have smartphones. And the people who don't or who don't have good internet service have been able to figure out to go park in the McDonald's parking lot or the Starbucks parking lot or borrow a friend's phone or go to the library. And Pro Bono Indiana gave us 3 tablets to use. So if you do have to come into court because you don't have your own smartphone or device, that's fine. We have a little iPad type thing we'll set you up on, and we'll get it loaded up for you, and you can go and do court that way so that everybody has a right to get these services. We are really thrilled about it. So what happens then first, here are the 3 parts of the Eviction Prevention Project: advice, mediation, and checkout. Legal advice, they talk to an attorney for 10 to 15 minutes. And they will learn if they have any defenses to the eviction, if they're the tenant. If they're the landlord, they'll learn whether they have a valid case. A tenant will often find they do not have any defenses because Indiana doesn't give you very many defenses. This is not like a magic solution we can come up with. It's making the best of a bad situation, and best doesn't mean good. It might just mean slightly less bad. Let me be clear. I wish this were magical. It's not magical. The legal advice might be, see if they'll agree if you move out in 3 weeks instead of 2 and you'll pay them a little extra. Or it might be, they didn't write down a reason on your notice of claim, ask to have the case dismissed. It might be, little tips, depending on what it is. Then we send them to mediation, and they try to work out an agreement. The mediators from CJAM fill out a form that says what the people agree on. They all come back into my courtroom on Zoom. They share their screen, show me the mediated agreement. I review it with them. I make sure everybody understands it, and it's what they really meant to agree to. And then I sign an order accepting it, and it becomes as important as an order of the court as if I'd issued it in the first place. The mediators email it to my staff, and we issue it along with the document. So it works out real well. Most of the time, I would say 80 to 90% success rate on mediations in eviction court. What that means is normally it doesn't count as an eviction. It counts as the case being dismissed. And what is huge about that is that now you can expunge it. Okay, that is huge. So again, let's just thank Gabby and Tonda there in the back for their work on the Eviction Prevention Project. Super grateful. Our community partners on that are the Community and Justice Mediation Center, Indiana Legal Services, Pro Bono Indiana, and we work often with HAND and with the Township Trustees' offices to coordinate referrals and et cetera. After mediation, then the tenants go through a process called checkout. And that is where they meet with a couple of different people, one each, and they will learn about anything else that might be a good resource for them. So typically Tonda does our checkouts or has helped train the other checkout person. And what happens is they might find that they lost their food stamps, and that's why they got behind on rent. And so maybe they need to be referred to the food stamp program at Indiana Legal Services, or they had their veterans benefits cut, or they lost their job because they were a certain racial or ethnic minority. They might get referred to a fair housing or a fair employment kind of a place. So it's looking at underlying causes and trying to get them some help. If they are going to have to move out and they're disabled, is there a place we can send for them to try to get help with that? Okay? I no longer cry on Thursdays, so thank you all. I appreciate that. Having that service really helps. So again, at the initial hearing, I'm either going to dismiss it because the plaintiff did not appear. I'm going to default it because the defendant did not appear. I'm going to approve a mediated agreement, or I'm going to set it for a contested trial. Those are the 4 things that can happen when you come to the first eviction hearing. And I would say out of every 10 cases, maybe 1 is going to go to a contested trial, which is great. It's fantastic. That is also a savings for taxpayers because we need less court time overall to hear these cases. Yeah?
2 to 4 weeks after the 6 weeks.
Yeah, it sure is. Because again, I'm hearing things into February right now. So right now, it's more than 2 to 4 weeks for a contested bench trial. So if the landlord knows that, they're a lot more likely to be willing to agree to 3 weeks for a move out instead of 2, which is my normal is 2. If you come into court and the landlord has a perfect case and I'm going to have to evict you, I'm going to give you 2 weeks. If you have a disability or a lot of really young children, or there are really special circumstances like you own the mobile home and you don't have a way to get it off the lot until your next paycheck, which is in 3 weeks, I might have some wiggle room on that. If there are allegations of damage or waste, I'm going to go lower than that. I'm going to go to 1 week or just a few days. But typically, I start with 2 weeks as my default. So if you're in a mediation and you know that my calendar is booked solid, maybe you agree to 3 weeks because that's faster than waiting for me. I often have people ask at the beginning of initial hearings, when's your first contested trial date, Judge? I'm like, November. Ha 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 ha. Sorry. Yes, dear.
You get an eviction notice, and then you're there for 30 days. Do squatters' rights still count?
We don't, let me think about that. Yes, actually, that's a great question. An order of possession, so an eviction order, is only good from 30 days from the time specified on the order. So if I order Charlotte to move out by October 31st, and her landlord is trying to be nice and patient with her and doesn't make her move out, and it gets to be December 1, that's more than 30 days, they have to file a new case. He's taking it over? Well, then we'll have to see if you have the rights of subletting or assignment in your lease. Question?
What if you've mediated a date for them to be out and then they don't get out?
Then I will order them out with no further hearing, if you file a notice and tell me that. A day or two. Yeah. If you have come to a mediated agreement and the other party has not fulfilled it, there are consequences for that. Because otherwise, how can I, if I don't honor people's agreements, how can I expect them to make an agreement, right? Yeah.
Do you hold lawyers or the plaintiff responsible for like not telling you the truth? So do you have any recourse, whereas if the landlord comes in and tells you, you know, I'm moving into the house, I'm going to move in, and then as soon as you get out, he moves somebody else in there and he lied to you, does that make any difference?
That particular case, no. If the landlord or anybody lies to me in court, they are vulnerable to a charge of perjury, which is a crime. They're also vulnerable to being held in contempt of court, which can include incarceration, community service, and all sorts of things. When I get mad, I get creative. I had a couple who was slapping each other at child and pickup drop-off in a family law case, and I made them each do a 10-page research paper on the impact of conflict on children. That was fun. Question over here? Yes. I'm getting my steps in today. Thank you.
For some reason, I've spoken to people in the community who think that they have 30 days regardless after you tell them to go. They're like, I got 30 days.
No.
Okay, I learned that today.
No. On my eviction order, if you look, I don't think I have a copy of the eviction order here. I probably should have. I apologize. They must move out by this date at this time. That's the date and time. If they don't move out by that date and time and the landlord has to file a notice of immediate possession, bring the sheriff out, get them thrown out on the street, are they going to have an opportunity to pack up all their stuff and take it with them? No. Are they going to have an opportunity to insist that their things be treated nicely? No. Are they going to have a right to not have their TV stolen? No. Is it going to be thrown out in the parking lot and will it get stolen? Yes. They have to move out by the date and time of my order. If not, they're risking having to pay additional attorney fees for the attorney for the other side having to file more stuff. Right? No. Obey the order. Yep.
Sorry, just a clarification on if someone's out. Is that turned in keys?
It depends. Do y'all love that answer? It depends. Right? Maybe they lost the key. Maybe it's a keypad. Maybe they left one key on the kitchen counter, but they can't find the other key because it was a bedroom by bedroom unit, and the other unit bedrooms are still there, and they don't know what happened to it. Maybe they were in a domestic violence situation, and their abuser took the key and threw it in the creek. I don't know. So various situations. As long as it's not a specific case.
There's no contact between you and the tenant.
Right.
And they were given a date, they said they'd be out, but no one was ever.
Then you'd have to go check it.
And you check it and there are items in there, you should assume that they're still there.
Then you should follow Indiana law on whether you believe those possessions have been abandoned as per the statute. And that may mean you have to warehouse them, and it may not. Because one of the other terms of the mediated agreement is typically that you're going to move out by a certain day, and that any personal property remaining after that day can be considered abandoned. Because that is another carrot for the landlord. Remember that statewide facilitation program that doesn't work? It's because the landlord had no advantages under it. Any agreement that is only good for one side is not going to work. So the landlord has to have some rights in this process too, right? I mean, I've been a landlord, I've been a tenant, I've been both. It sucks either way. But the landlord needs to know that people are going to follow their agreement and that they have some certainty about what to do with the stuff. So if there's a mediated agreement that says it's abandoned after that date, they can throw it away even if it's a diamond ring or a winning lottery ticket. And they can keep it and do whatever they want. I'll be over in a second. Yeah, here you go.
Okay, so there's a mediated agreement that says I'm going to move out on October 30th. I've got a nice landlord though, and they want to be nice to me, and got my kids and I'm homeless and whatever. And so they can't let me stay past that day. They can let me stay 30 days past that day?
Correct.
But if they let me stay 21 days past that date?
That's okay.
Great.
If they let you stay 35 days after that date, you might still move out voluntarily, but if they want to force the move out at that point, they're going to have to file a new case, pay a new filing fee, and boy, are they going to be mad, and boy, am I going to probably grant them every attorney fee they ask for, right?
More than 30 days, that's just really a very good faith situation that might come back.
Yep. Where was the question over here? Yeah, sorry. I lost track.
So if you're down to your last 5 days of your 30 and all of a sudden we have an ice storm rolling on in, doesn't matter, they still lose it all?
Yep. Yeah, there's a concept in the law called force majeure, which means a big force. It's sometimes referred to as act of God, right? And that might be an ice storm or a hurricane or something like that. But my orders don't contain a force majeure clause because they're really hard to define, right? So you should have taken action before that last 5 days. Sorry about you. Yeah, it's not great, but there's got to be some certainty for both sides, right?
What if a blizzard comes in and then we have 15 feet of snow and
Then,
we can't get the notice?
too bad.
Different question. If somebody's lease is up and they don't move, what happens at that point?
That is effectively a breach of a lease because they're what's called a holdover tenant. If your tenancy was supposed to end October 31st and you're still there on November 15th, the landlord can file for an eviction because you have breached the lease. Yep, does that make sense? Question?
Regular eviction, not an emergency.
It's a regular, not an emergency. I don't care if you have another tenant ready to move in, that's not an emergency. We can solve that with money. In other words, if it is an emergency that can be solved with money, it's not an emergency. Because the landlord could put the new person up in a hotel for a week and then ask for that in damages. It's not ideal, but it's not an emergency. Yes, dear. They could still get a hotel. Yeah, I'm just, theoretically, right? Okay, that's right. Am I doing okay? Ooh, I have like 16 minutes left. Okay. I am not done yet. Dismissal, we've talked about dismissal and default. Okay, here's the eviction prevention project. If you have a tenant or a landlord with questions and they want to talk to somebody, send them here. Okay? If you're ready to write down this phone number, let me give it to you. The phone number is 812-340-8189, and the email is evictionavoidance@gmail.com. Can a small claims case be mediated? Yes. Contested eviction hearing, here are the preferred exhibits. And I'm going to start to go a little faster, and I'm going to ask you to hold your questions, because if we don't get to Jeopardy, you don't get the candy. Okay? Because I know you want candy, right? I want candy. I'm drooling over here. Okay, preferred landlord exhibits for an eviction hearing, contested in the courtroom, bring 3 copies of these things. A lease. If you need the notice to quit, bring the notice to quit, but most of you don't. Occupancy permit, if it's in the city of Bloomington. Somebody recently told me mobile homes are not required to have an occupancy permit if they're in the city, but I read the statute or the ordinance like 3 times. I don't see that in there. Yeah? Yeah.
The state of Indiana took away our ability to enforce anything inside of a mobile home park. So if it's a freestanding mobile home on a city lot, it can have an occupancy permit through hand. If it is inside of a mobile home park that is licensed by the state of Indiana, it falls under the purview of the state health department to inspect.
Okay.
They
So,
have,
city rules don't apply anymore.
they do not. There are 2 inspectors for the state of Indiana for every mobile home park.
Yeah, that's great. That's effective. Okay. Any proof of violation of the lease? Ledger showing non-payment, pictures of waste, et cetera. Preferred tenant exhibits, the lease. Any proof of compliance? Should you pay cash to your landlord and not get a receipt? Oh, please, God, don't do that to me. Okay? Get a receipt, show a payment ledger, something. Then we get to the security deposit letter. Again, I'm going to go kind of fast. The landlord, within 45 days of getting a forwarding address from the tenant, has to send a security deposit letter that itemizes the damages. If they don't get a forwarding address, they don't have to send the letter. If there's no security deposit, they don't have to send the letter. So if you're a tenant, always give a forwarding address. It doesn't have to be yours. It can be a parent or a family or a friend or 620 South Walnut or anything that they need it to be, okay? But give a forwarding address. Under the statute, it says mail. Could mail be email? I think so, so I'll use an email address as well, okay? If the tenant does not provide a forwarding address, there's no need for the landlord to do a security deposit statute letter. Then we get to the damages hearing, which is where I determine who owes whom what for late rent, damage to the unit, attorney fees, late fees, court fees, etc. The hearing involves first an initial hearing, where again there could be dismissal, default, or agreement, and then a contested hearing for eviction or for testimony and exhibits. Those are both considered evidence. The initial hearing again is by Zoom. We do the same steps with the Eviction Prevention Project. The Eviction Prevention Project, same numbers as before. For the exhibits, the landlord damages form and tenant damages forms are on your tables. I was going to make you fill them out, but we don't have time, so I'm going to just say please look at them. They are required in Monroe County for both Judge Saltzman and myself. Don't come into my court for a damages hearing without one of these, or I will not hear your case, okay? I want to know a breakdown. I don't want to look at an 18-page ledger with 6-point Arial font of what was a late fee and what was rent. I want it summed up. I want to know, are you looking for $2,400 in late rent and $2,800 in late fees? Well, then I'm probably not going to grant all that. I want to know if it's reasonable. I want it summed up by category, just like on here. One of the landlord attorneys asked me, shouldn't the tenants have to fill out a form? And I said, you know, that's a great idea. So I made a tenant form. You'll see it on your table. Those are all the things a tenant can sue for. There's probably more than that, but that's what I could think of. I like to see a move-in and a move-out inspection. In the city of Bloomington, those are required to be kept by the landlord for a period of 4 years or 2 eviction cycles. If I don't know what damage was caused before the tenant moved in, then how do I know it's their responsibility at move-out? So I want to see the before and the after. Okay, we're not going to fill out those forms, damages forms. I'm not going to make you fill it out. Questions I'm going to get to, but first we're going to play Jeopardy. All right, kids, are you ready? You're ready. Are you pumped? All right, get yourselves comfortable, because I think this is going to work. We're going to find out. Okay, this is going to be fast-paced, okay?
Rhyme time.
So here are categories: filing an eviction, fighting an
Movie
eviction,
classics.
eviction hearings.
Broadway musicals.
This is so exciting. I know, right? Damages
Easy
hearings.
but so mean questions.
I'm a huge geek. I love this. Exhibits.
Hairy affair.
Good to see you, Charlotte. Thank you for coming.
Popular speeches.
And graphic. All right, who's going to be first? You get a lollipop just for trying. Kids, you ready? Okay. Let's see here. I think I have to come over here. Use the mouse. Filing an eviction. Filing an eviction? $87 if by internet, $97 if in person. Nope. Anybody? What? Nope. Filing fee. Whoever said filing fee gets it. Okay, next one. Nope. Okay. So we did filing and eviction. I have to get back here. Okay, we did that. Okay, now who? Somebody? Damages hearing for 400. Bring her a lollipop. Beyond normal and wear and tear. What is beyond normal wear and tear? Okay, let's get there. Red shirt. There you go. Give the guy in the red shirt a candy. What are damages a landlord can deduct from a security deposit? Keep in mind that a lease can define normal wear and tear differently than I might, because Indiana is a freedom to contract state. Next one. Grab bag 600. Clothing with swear words or drug references, interrupting to the point the court cannot go on, or punching your attorney are all examples of. Woohoo! Okay, take those out. What might get you held in contempt of court? How much fun did I have with this at midnight last night, right? Okay, who's next? Okay, if you are answering the question, keep your hand up so they know to bring you a candy. Okay, next. Come on, we can do it. We can get through. Fighting an eviction, 400? Deliver the rental premises to a tenant in compliance with the rental agreement and in a safe, clean, and habitable condition. What is? Woohoo! What is one of the landlord's duties? Safe, clean, and habitable. Delivery. They don't have to keep it that way. They have to deliver it that way. Okay? Did you get a lollipop? Okay. Who's next? Come on. You can do it. Come on. Eviction hearings 1,000. Under these circumstances, a landlord cannot terminate a lease except for good cause. What are these circumstances? We talked about it earlier. Depending, I'm going to give it to you. What is under some federal subsidized housing programs? Nice work. Okay, we can do it. We can do it more. Exhibit 600. Receipts. I love it. Give that lady a candy. Okay. Hey. You should be quieter than me. Lady in the blonde hair needs a lollipop and a candy. What is one of the best ways to show your costs is what receipts are. Okay, next. Exhibits 800. Letters from neighbors or contractors. Yeah? We're all getting there, we're getting close. What is permitted as evidence in small claims court is what I was going for, because normally in regular court that would be hearsay, but there's no hearsay rule in small claims court. So you can bring in a letter from anybody you want to. Okay? All right, next one. Which one? Filing eviction 1,000. Personal, left copy, mailed copy, certified mail, or special order are all examples of give that lady a chocolate. Common methods of service of process. Okay. Come on. Fighting an eviction for 600. The landlord has been given a reasonable amount of time to make repairs or provide a remedy of the condition described in the tenant's notice. The tenant may not prevent the landlord from having access to fix it. Is an example of when a tenant can. Nice. What I have down, what is one of the times a tenant can sue the landlord? Right? Okay. Next. Filing for 600. $6,000 is the limit for in the back? No? Yeah? For a full-time employee to represent a business, that's the maximum in small claims court. Otherwise, it's $10,000. Yep, good one. Thank you, children, for doing the chocolate deliveries. Okay, what else? I got some. Over this side of the room? Grab bag 1,000. 3. Judges Hazeman, Crothy, and Stafford have this in common. It's much stupider than that. We all went to North. You would never know that. Give them chocolate anyway. I was getting real tired. All right, what's another one? We all overlapped in high school too. We're all local. Damages for 800. Only unpaid rent, no damage to the unit. What is all a landlord can collect if they do not send a 45-day security deposit letter? They can get their rent back, but they cannot get any damages unless they do the 45-day letter. So you want proof you sent them your address, right? Okay, what else? Shh. Come on. Which one? Eviction hearings? 600. The landlord's notice to quit means the tenant has to move out. Good. The tenant doesn't have to move until the court orders them to do so, but it is a great opportunity to try to work together to negotiate or mediate and maybe move out before the landlord files so you don't have to deal with a court case, right? Okay, we're almost there. We can do it. We have 5 minutes. Damages hearing 600. Other damages 250. Okay, and this one is not fair because I didn't tell you about it. What is not specific enough to get me to make you pay for it? You have to specify the damages on the security deposit letter. You can't just say miscellaneous. I'm not going to give you funding for that. Maybe that's the Kit Kat you bought at Menards when you were buying the blinds. I'm not do you know how many times every week somebody sends me a receipt from Lowe's with a Kit Kat and a Diet Dr. Pepper? I'm not making the tenant pay for your Diet Dr. Pepper. Okay, what's next? Somebody else. Filing an eviction? No. What'd you say? Fighting for 1,000. Okay. Landlords must keep property in a safe, clean, and habitable condition. This is known as the warranty of, woo, nice. Habitability, warranty of habitability. Okay. Who else? Permission before you throw, no torts. All right, we've just got a few left. We can do it. Exhibits 400. Damages form. What is required by me? What is perhaps the most important exhibit for damages hearing? I'll count that. Bring me the form, summarize it up. Yeah. Okay, we get this. Come on, somebody else. Damages hearings 1,000. Set off. What is a set off? If the landlord is asking the tenant to pay them $4,500 in damages and the tenant has not filed a counterclaim but has some costs they think they should get, the court can do a set off. The tenant should file a counterclaim in that case, probably, but I can still consider a set off. Okay, thanks. I appreciate that. Okay, that's enough. Don't hurt me. Okay, what's another one? We have 3 minutes. Eviction 800. Filing an eviction? Okay. A brief statement of the nature and amount of the claim. It goes on the notice of claim. Yeah? The minimum description on a notice of claim. You got to tell me why you're suing them, right? Y'all are doing great. Frankly, great. Okay, we just got a few left. Exhibits 1,000. 3 copies. What to bring to court? Give it. Yep. What is the right number of exhibits to bring to court? 3 copies for yourself, the other side, and the judge. Okay? Come on. Eviction hearings 800. The landlord can lock out the tenant if the tenant does not move out after getting a notice to quit. Love you all so much. What is false? That used to be the law in Indiana, but that changed and it's no longer the law. Seriously, that used to be the law. Damages 200. 45 days. What is 45 days? Right? It's the deadline for the security deposit letter after the tenant provides their forwarding address. Right? Red sweater, Efrat. No? Mary? Emily? No? Okay, I'm not in charge. All right. Grab bag 400. Business casual or formal? Give yourself candy. What's the preferred, okay, don't hurt me. Dress code for court. Business casual is great, formal, but I once told a client formal and they wore their prime dress, so be careful how you phrase that. Okay, what else? Grab bag 800. Magic legal language. Okay, that's good. What does not get required in small claims court? I'll give that. Who said doesn't exist? You get candy. I heard a grab bag for 200. 9. Woohoo! How many judges are in Monroe County? All right, we just have a few left. It's 1:30. Give me like 2 more. Exhibits 200. Lease. Yeah, but we're in the exhibits category. It's not required, but it's really a good idea. Please bring it. Okay? We got one more, and then I'm going to close. Yeah. Complaining to the government about a housing code, complaining to the landlord about violations, bringing an action against the landlord, organizing or testifying in court are all examples of protected activity. That's all we have time for. Yes, please, go get as much candy as you want. And thank you.
All right, let's give it up again for Judge Stafford. That was amazing. Thank you so much. So how many people learned something today? Awesome, that's what we like to see. Thank you as well. I'd like to give you all a round of applause because for every day you are working to strengthen housing security in our region. So clap for yourselves. Yay. Take candy. If you didn't grab a lunch, please do. There's some extras there. On the table, there's a QR code. We're asking for feedback for this session. It's really helpful for us, or ideas for other sessions, so please use that. This is my contact information if you'd like more information about heading home. If you have signed up outside at the table or registered today, we'll be sending a follow-up email with the slides that I'm going to get from Judge Stafford. Yes? Yeah. Okay. And other information about heading home. Have a great rest of your day. Thank you so much for coming.